Charmed Life Therapy, powerfully and subconsciously changing your life. Hi, it's Anne-Marie again from Charmed Life Therapy. I've woken up to like 12 million emails. Luckily, some of them aren't available just yet. Otherwise, I think I probably would have had a meltdown at the idea of trying to catch up in one day. Later on, hopefully, I'm going to do a video because J. Alexander Townsend has been busy on the docket again, and they're always fascinating to read and break down. But there was also this letter from Lina Friedman from, I think it's Ellyn, yeah, it's Ellyn Garofalo. Garofalo, it might be. And yet somebody will have to tell me how you correctly pronounce that name. I don't like to get people's names right. It's people always get my name wrong, so it kind of does bug me getting people's names wrong. But yeah, so this is a reply to Leslie Sloane chipping in the other day. We had kind of a little barrage of people kind of putting in excess letters. You'd even have to class Perez over in Las Vegas as chipping in with excess information in the form of letters, and courts don't tend to like that very much. So the Wayfarer parties have jumped on this really because Leslie, when the James Vituska thing came out the other day, him altering the definition of his affidavit, if you like, people came out of the woodwork and were like, see, Your Honour, weren't they? So this is Wayfarer's response to this, which has dropped in overnight, my time kind of thing. So, dear Judge Lyman, on behalf of Wayfarer Studios LLC, it ends with us Movie LLC, etc., etc. We don't need to do that. We respectfully submit this letter in response to Leslie Sloane and Vision PR Inc.'s sur-reply, filed without leave of court in support of her motion for attorney's fees and costs. As leave of court was not obtained prior to the filing of sur-reply, it should not be considered by the court in deciding Sloane's motion for attorney's fees. Case law cited there, as you can see, which ended up in striking a supplemental filing where the plaintiff neither sought nor received permission from the court to file a sur-reply. So even if leave had been requested, the sur-reply must be disregarded for the reasons set forth below. First, Sloane disingenuously suggests that this is the first time she has asked the court to consider the text contained in Exhibit A to the August 21st declaration of James Vituska, a former Daily Mail reporter, but Sloane had already cited, relied on, and discussed this exact text message in her reply brief in support of her motion for attorney's fees, docket 420, page 7 or part 7, citing docket 193 at page 16. The Wayfarer party's complaint filed in the LA Superior Court, which included an image of this text. Sloane's sur-reply is thus improper. Second, the text message is not conclusive evidence. The text purports to comment on a screenshot of another text message between Vituska and Sloane, which is not included with Exhibit A. Referring to the screenshot of a text between Sloane and Vituska, Vituska says that in that exchange, Sloane does not say anything about SA. That does not demonstrate that Vituska never said that Sloane told him Lively was essayed or harassed, nor are the Vituska declarations reliable. The two declarations are inconsistent with one another and appear to be internally inconsistent as well. Further, Vituska's credibility is suspect as he was fired from the Daily Mail because he shared the text message quoted in the Wayfarer party's complaint and insinuated himself into the story rather than just report on the story. His effort to distance himself from that text is not surprising. In any event, Sloane can only speculate that the text quoted in the Wayfarer party's complaint is the sole support that Sloane told Vituska that Lively was essayed. The recycled text in Exhibit A is thus not the smoking gun Sloane pretends it is. Vituska's inconsistent and ambiguous statements, which have not been subject to cross-examination, cannot establish that the Wayfarer party's claims were wholly without a substantial basis in law or fact, or filed in bad faith. Finally, even if Sloane could successfully disprove that a text quoted in a single sentence in the Wayfarer party's complaint was later recanted by Vituska, she cannot. That would not mean Sloane's motion for fees should be granted. To begin with, Sloane's motion was procedurally improper. As the Wayfarer parties pointed out in their opposition, a motion after a Rule 12b-6 dismissal is not the proper procedure to seek fees under New York Civil Rights Law 70A. Docket 382, I don't know whether that's paragraph or something 9 to 10, on its face, 70A applies only to an action, claim, cross-claim, or counterclaim. The overwhelming majority of courts in this district interpret the language in this statute to require parties seeking anti-SLAPP damages to bring an affirmative claim for relief under 70A, not proceed by a motion after a dismissal. Even assuming a motion is a proper procedural mechanism to seek fees and costs under 70A, the Second Circuit and the majority of district courts within it hold that state anti-SLAPP motions do not apply in federal actions. The rationale for this rule is that state anti-SLAPP statutes conflict with federal rules of civil procedure 12, 56, and 11, as they address the same questions. The Second Circuit has held that California's anti-SLAPP statute does not apply to federal courts sitting in diversity, although the Second Circuit has not spoken on whether New York's anti-SLAPP provision applies in federal court. Most cases in this district, including Brady v. NYP Holdings Inc., hold to the contrary. I guess all of this, we had the little bit of the deposition last night that was unsealed, and there were questions there about the jurisdiction and the movie, and did this happen in California? And, well, did this happen in California kind of thing? I guess it's kind of like we all feel kind of about Wayfarer, that there's a lot more that they know that we don't know, and this Vituska thing has always been quite interesting because it's always been a case of what verbal conversations were had, that we've not got recordings of or whatever, or probably aren't recordings of. We don't know what this guy has said basically, and I just wonder if it's such a funny case, is this, because she used the jurisdiction element to try and give her an advantage. Yet it's also the thing that is tripping her up, Blake Lively, as well, when it comes to Jed Wallace and trying to use the anti-SLAPP and all of the rest of it. Because you can't cherry pick and have it all fall in your favour, basically. And Sloane's going to have the same problem here, clearly, as well. Further assuming Sloane were able to overcome these procedural infirmities, she cannot. To be entitled to attorney fees, Sloane must prove the Wayfarer party's claims against her were wholly without a substantial basis in fact and law under 70A, or that all claims alleged against her were made in bad faith pursuant to the court's inherent powers. The Wayfarer party's defamation claim against Sloane included far more than what Vituska said in the one text message referenced in the complaint. The Wayfarer parties alleged Lively, Sloane, and Reynolds worked together to spread a false narrative about them to the New York Times to the effect that they engaged in inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruining her reputation, and also alleged that Sloane individually made false statements to other press outlets that Baldoni had committed sexual misconduct. The allegations included that Sloane and others concocted a plan whereby Stephanie Jones would seize Abel's phone upon her departure and mine it for messages that, stripped of context, could be used to concoct a false narrative that the disastrous press coverage of Lively's callous and opportunistic comments and the public reaction to those comments were not Lively's fault, but the result of a calculated, though in reality non-existent, smear campaign by Baldoni and his team. in some Sloane sur-reply, which merely rehashes an argument about a text message she already made in her reply brief, does not alter the conclusion that Sloane's motion for attorney fees must be denied. So I think that is a little humdinger of a response there, as we generally feel with the Wayfarer Party's responses. It's almost worth the kind of abuse feeling that comes from Blake's side to get one of these that pops in afterwards, because they're kind of calming to the nervous system, I find. I don't know about you, but I it's interesting, isn't it? It kind of implies to me that Wayfarers still have a lot of eggs in their basket, if you like, that they haven't let on to us yet. And is it kind of because kind of like, because we have said before, is there a way that they're trying to make it criminal or aspects of it criminal? Or is it that because they feel like they're dealing with narcissists, and that, that when you're dealing with somebody like that, they can pivot at any given time. So you kind of don't want to give them too much information too early, because they might do something with that. There's a lot of kind of criticisms floating around from Lively's side about things that haven't been released, or this side of the conversation proves that things are missing from this other side of the conversation, and things like that. And if that is true, maybe it's because Wayfarer is dilly-dallying on presenting that, because they have to be very careful in terms of what ammunition they give these people. Perhaps there's an aspect of that to it. But yeah, I just wanted to bring you that one quickly, because there just seems to be a lot of information coming in, and you cannot possibly do it all in one thing without missing key elements of it. So I just wanted to bring that one to you this morning, and please do hit that like and subscribe and share if you're enjoying this at all. Appreciate your comments. If you drop me a comment, I will do my best to get back to you. And I will see you again soon. Drop a like and subscribe, and please check out the description box. There's often free resources there.